Hello, everybody.
We can call the matter of Alexander Zarate.
Alexander Zarate, CB 011-0629-4A026-7392, XZ 050-8291, XZ 01-87933. Good morning, Mr. Zarate. I have what appears to be a statement on the definitive plea of guilty. An opportunity to go over this with your counsel. And do you understand everything that's in it?
Yes.
Great.
Oh, yes.
And, okay, you understand?
I can't see you very well. Pardon me for that.
Okay. You can hear me okay? You can hear me okay?
Yeah, my eyesight kind of helps me not hear too well, too, for some reason. But yes, I can hear you.
Okay, good. Well, I have before me a statement on plea of guilty to the charges of malicious mischief in the third and driving under the influence. You understand that you have certain important rights that you're waiving by entering such a plea, specifically the right to be presumed innocent, the right to have a trial, the right to hear witnesses against you, and the right to bring witnesses to testify on your behalf, as well as the right to appeal, that you're waiving these rights by entering a plea. Do you understand that?
Yeah, it's a plea bargain deal.
Okay, you understand that I'm not required to follow the deal, that I could decide to sentence you up to and including the maximum of 364 days and $5,000 in fines for each charge.
Yes, I heard that.
Okay, and knowing all these things, do you still wish to go forward?
Yes, I do.
You understand that if you're not a U.S. citizen, I'm asking whether you are, that entry of these pleas may make it difficult for you to become one.
Okay.
Okay, and I'm assuming there will be motions by the city.
Yes, after you take the plea, the city will be moving to dismiss the other remaining charges.
Fantastic. Sir, as for the charge of malicious mischief in the third degree, how do you plead?
Guilty?
And as to the charge of driving under the influence, how do you plead?
I plead guilty.
Is there a statement that facts are sufficient? Do you believe this to be knowing and intelligent defense?
Yes, Your Honor, there is.
Pardon me? Oh, excuse me.
And with that statement, I will find that you are now guilty of those two charges. City.
Thank you, Your Honor. A couple of these charges that the city is moving to dismiss, the harassment, the reckless driving, were from older cases from 2020. They had pretrial orders. I think at least one of them involved a neighbor, allegedly. The order has already expired on those, so the city's just moving to dismiss. They're older cases. It's part of a global resolution. There's really, and as I stated, the pretrial anti-harassment order would have already expired on that one. The malicious mischief third, the city is actually the victim in that case. The neighbors had seen Mr. Zarate taking, I think it was a hammer or some sort of thing to a city street sign. We discussed restitution. The city will just figure that one out on its own. We're not asking for the court to try to monitor or figure out restitution on that. The more sort of, I guess, serious case is the DUI that is the most recent, and that's just from February. He's been in custody since that time. There was a competency evaluation that was completed. The defendant's been found competent. And in this case, it is a first offense. It would be a 1B. It does have some aggravating factors, which is why the city is recommending 5 days on the case. The defendant rear-ended another vehicle at a stoplight. The victim vehicle called police to obviously report the incident, but also believed that the defendant was under the influence of some substance. He was found to have the physical signs of being intoxicated. He did admit to consuming some wine prior to driving. The officers also believe there was some empty alcohol or some types of alcohol containers in the passenger side vehicle of the car, and they marked that his intoxication level as extreme. So there was an accident. He ended up refusing to provide a breath sample. So it is a 1B. The city's recommendation is essentially for standard fines and fees, the $953 fine plus the $250 and $43 conviction fee. ERC cost is $266. We are recommending 5 days instead of the standard 2. That's because of the aggravating factors. And then the dismissal of the driving suspended a third-degree charge as well. I just asked the court to follow the recommendations on that and the malicious mischief. Mr. Zarate has had some other cases in his past, but he's had no prior convictions for the same. he had a malicious mischief from 2001, I guess, here in the city, but a number of years ago. So taking that all into account, the defendant is well past credit for time served, and we just asked the court to follow the agreed recommendations today. Thank you.
Thank you. Defense.
Your Honor, this is an agreed recommendation. We would just ask the court to follow that today. The main thing here was that there are some older cases, certainly, as the city pointed out, from 2020. Mr. Zarate had, as he would put it, that he did not receive summons on those. He really didn't have an idea that he had those matters. As of right now, he has taken responsibility for the DUI as well as the malicious mischief. I think he's mostly doing that to take advantage of this offer here. But at the same time, he understands that there are certain facts in this. I think the officers were even training several other officers at the time, and they had actually gone over everything, kind of crossed the T's, dotted the I's, so to speak. There's also a number of things where they were going over the RCWs with them. I mean, it was fairly in-depth. I don't think I've seen a body cam where they've gone into that kind of in-depth with a lot of these matters. So he is here. He's taking responsibility. We would just ask the court to follow us today. Thank you.
Thank you. And Mr. Zarate, you're not required to make any statement to the court, but if you wish to do so, you may do so now.
Well, that's irrelevant, I think, right now. So I'll pass on that.
He said he'll pass.
Okay, thank you, sir. Give me 1 second to fill out this form. And just so I'm clear, the harassment is dismissed, reckless driving dismissed, and D3.
The driving thing,
dismissed.
correct. Yep, the city moved to dismiss all three of those charges.
And no objection from the defense, granted.
Correct,
just
Your Honor.
filling
No
out.
objection to the dismissals.
What's the 43? Is it CCR? Just not the response one.
Remember, he passed his competency eval.
Okay. And what was the total fine amount? All right, sir. The court has entered your pleas of guilty, and for the sentencing on the malicious mischief, it'll be 10 days jail with credit for any time you've already served. Fine.
So, yeah, it should be, the 953.
I don't know why they didn't populate. That's why I didn't know.
Why did the DuckTales theme just pop in my head?
Yeah. Okay. You will, on the DUI, it is 5 days custody, and fine of 900 and...
953 is
53.
I wish it gave the actual numbers here. I'm really bad at math. All right, 953 on that one. And you'll be on probation for a period of 24 months. So your total amount, so $12.53 in fines, $266 DUI emergency response fee, and probation monitoring costs of $2,400 for a grand total of $36.53. If given an opportunity to make payments and time to pay that, would you be able to pay that fine amount?
Yes, but
That's what the statute
my plea deal bargain, I was interested in getting
statute requires them to be sentenced to treatment. And if they want
the probation,
to be here, you're
24 months of probation dropped.
Is there some agreement regarding probation?
And, Your Honor,
Yeah.
while
Go
we were
ahead.
discussing this, I think the statute requires the sentencing to a treatment and the 2 years of probation. I think there is I think there's certainly going to be a request for that revocation as we go forward. I think that's both. I think everybody's opinion in that matter, but I certainly would be asking for that as we go forward. I I don't believe Mr. Zarate would be, following through with, these matters, but that is certainly something we can have at the first review hearing, is something we can have addressed with the court at that time.
You can note it now if you want to, for a week or two out, if you don't want to wait that long.
That's true. See what's available. And we would request actually a review of those conditions in about another week or two, if that's okay with the court, if we have space on one of the Wednesday calendars.
I was led to believe there was something done today.
Well, you'd be out today for credit for time served, but the commissioner's reading, and he indicated to my office recently that the statute changes now, this idea of revoking up front at which I think is what Mr. Zarate would like to do today, that the statute no longer allows that you actually have to sentence them to that. So if he wants to be released today, then come back to the court in a week or two and request out of custody to be revoked, then we can look then at what that would be. The city's not opposed to that, I guess is what I'm getting at, but I do think for today's purposes, he would need to be ordered to probation, released from jail, and then we could review it, and whatever works best for the court or for the defendant is fine with the city.
I just don't want to be framed here.
Okay. Third, I'll go over the statement here real quick. For payments on your fines, how would you like that to be scheduled? And I understand what you're asking me about probation costs and fees, and that will all be addressed when you come back. The court is going to have to sentence you in this way now because it has to comply with the law. Okay, so I am going to sentence you to probation. It's going to be a period of 24 months. I'm going to have to include all those costs in this form, and we'll set a payment schedule and time frame based on that number. I do understand your request, and you can come and present that request to the court at a different time after you've been released, after the court has entered this sentence. Do you understand?
Could I do that with counsel from the
Yes.
court?
The counsel is not going to be withdrawing from your case because this is a probation case, so they are still your attorney of record as long as you are on probation and under conditions of this court, which may jeopardize your liberty.
And that's what I'm trying to get scheduled here in the next week or so.
All right, lawyer.
Thank you.
What is the amount?
Thank you.
Sir? Do you want to know how I'm going to pay it? I'll pay the whole thing with my debit card.
So I'm going to schedule this for a review on May the 22nd at 1:30 p.m., okay? And you can address that with your attorney in the court at that time.
All right. Can I get something that has that date?
I put it in the
On
order. It
there
will be
so I
sent to
don't
you
miss?
today. Yes, sir. I put it in the order, so it will be sent to you. Okay, it's part of your judgment and sentence.
I don't get mail, so I need to.
Huh?
Okay.
Yeah. And you'll get copies of everything before you leave there.
It'll all be provided to the jail there as part of your release packet.
All right.
All right.
Thank you very
There are
much.
certain mandatory conditions regarding with the DUI. You cannot drive a motor vehicle without a valid license and insurance. Do not drive or be in physical control of a motor vehicle with concentration of 0.08 alcohol or 5 nanograms of THC. You must submit to a breath or blood test for alcohol upon reasonable request of law enforcement officer, and I don't think he's required to have ignition interlock. Please comply with all requirements of the Department of Licensing regarding any license suspension and requirements for operating motor vehicles. Do have no new criminal law violations. Do not refuse to submit to a test of your blood, breath, or urine. Do not possess alcohol or any non-prescribed drugs like marijuana or any drug paraphernalia. Do not enter into any establishment whose primary purpose is the sale of alcoholic beverages or cannabis for use either on or off of the premises. You'll be on active probation for a period of 24 months. Are we ordering an SUD assessment or not?
I think you technically have to,
I
yes.
think so too, yeah.
Yes.
All right, you're ordered to obtain a substance use disorder evaluation and comply with those recommendations. You must appear timely at all scheduled court hearings. And I did note that you can review this in 2 weeks and set this for a review for May 22nd. Anything further on this matter?
Not from the city, thank you.
Great.
Nothing from defense.
All right, thank you, sir. We will get copies of all of that. Please reach out to your public defender upon release so you can schedule that next court hearing or discuss that next court hearing, okay?
Yes, and what is the amount?
Oh, yeah, what do you want your
The
payment
payments?
schedules to be set at?
I could just pay the whole thing, can't I?
Well, that would be $3,653. That amount may change based on any request you make regarding probation, because that includes probation cost of $2,400. Now, even if you are only on probation for 2 weeks, there will be some probation costs, but your fine amount is $1,253, and there is a mandatory $266 emergency response fee. Those must be paid. Would you like me to set a payment schedule for you?
For the $2,400?
Sir, for your entire fine balance right now of $3,653, would you like me to set a payment schedule?
Sure.
How much would you like to pay per month?
About $20.
All right, I will set it at $20. I'm going to set that to begin in 30 days. Please contact Signal Management upon your release to schedule payment. The instructions will be on the form when you receive it.
Okay.
All right. Anything further?
Not for me.
All right. Thank you, sir.
All right. Thank you.
Who's next? Mr. Alford.
Your Honor, we can call the matter of David Jenkins.
This is my favorite thing.
All right, I'm just waiting on my computer to catch up. All right, David Jenkins, 1A0534632, CB0106496. Good morning, Mr. Jenkins. Looks like we have a motion to continue to May the 22nd. Is that right?
Correct, Your Honor, with the speedy waiver.
Yes, sir.
I do see a speedy waiver and see no objection from the prosecutor. This matter will be continued. Do we need an out-of-court custody date? Your out-of-custody date is June the 25th. If you do make bail and you're not in custody on May the 22nd. Otherwise, we'll see you in court at 8:30 a.m. on May the 22nd. Thank you, sir.
Thank you.